Welcome to this one in a series of occasional programs featuring nuts and bolts 101 type issues brought to you by the Beverly Hills Bar Association Trust and Estates Committee. My name is Jennifer Campbell and I'm one of the co-chairs of the committee. Before I turn the program over to our co-program chair, Kevin Harrington, let's get some announcements out of the way. You will receive your MCLE certificate, materials, and a copy of the program in about a week. After the program, please take a moment to complete the survey. The survey link will pop up right after we conclude the webinar. The Trust and Estates section and all of its webinars are the Sanborn team, Geffen Real Estate, Glen Oaks Real Estate, and California Title Companies are sponsored by the Sanborn team, Geffen Real Estate, Glen Oaks Escrow, and California Title Company. Let me give you a few words about each of these fantastic sponsors. Sanborn team has been sponsoring the BHBA's Trust and Estates section since 2006. Serving clients for over 35 years, the Sanborn team gives members and colleagues attractive results and peace of mind with a depth of knowledge of probate trust and conservatorship unparalleled in the industry. The Sanborn team's ongoing sponsorship demonstrates a tangible commitment to the probate and trust community and BHBA. They are ready to handle any and all sales of real property in Southern California. Think of them first as your first resource for all your real estate needs. Geffen Real Estate is one of our new sponsors. Broker owner Urit Gadish is a high-energy, compassionate, and experienced real estate professional who successfully serves her clients and hopefully you, having sold over 1,400 residential and commercial properties statewide to date, specializing in probate and trust, including luxury and investment properties. Urit offers various programs to best meet the needs of your clients, including auction, occupation relocation resources, ordinary as-is sales, and renovate, pay now, and pay later. Urit is a fierce negotiator originally from Israel and currently lives on a fruit farm in Beverly Hills with her farmer professor husband and 4 young daughters. Also, we're sponsored by the Glen Oaks Escrow Company. Marcine Klein is a full-service escrow officer specializing in probate and trust sales, conservatorship, and both court and independent administration of Estate Act transactions. On a daily basis, Marcine works to ensure that even the most challenging escrows flow smoothly and that her clients are beyond happy with their experience with the Glen Oaks Escrow Company. California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans, and military personnel, as well as seniors, real estate agents, brokers, mortgage lenders, and commercial real estate professionals. And now I'm pleased to introduce one of our incoming program chairs and the moving force for this program, Kevin Harrington.
Thank you, Jennifer. Yeah, I'm Kevin Harrington, and I'm one of the new program co-chairs of the Trust and Estates section. Today, we are lucky enough to have Nancy Sanborn and Brenda Depew presenting to us on understanding the unique challenges of court-confirmed real estate sales. Nancy Sanborn is the Executive Director of the Trust and Probate Division for all of Southern California for Berkshire Hathaway Home Services. She has been working with the trust and probate community throughout Southern California for over 30 years. Brenda Depew is a partner of the law firm of Hinojosa and Forer. Brenda started as a paralegal with the Hinojosa firm in 1991 and in 2006 obtained her JD degree at the University of West Los Angeles. Brenda continued with the Hinojosa firm as an associate attorney in 2008 and became a partner in 2019. I understand that our speakers today have a packed presentation, and they will try to answer any questions that you have at the end of the presentation. I'll now let Nancy and Brenda take it away from here.
Okay. All right. Hello, everyone. All right. Brenda and I are here today to talk to you about understanding the unique challenges of court-confirmed real estate sales.
All right. So Nancy and I have been working together for a long time. Well, all my time here at Hinojosa and Four since 1991. Nancy basically was trained by Lynn Hinojosa, I believe, in probate sales. And you can't get any better training than that. I started as it was announced as a probate paralegal. And setting up a real estate sale is a really great job for a paralegal because there's a lot of nuts and bolts to it. And probate sales is a very particular area. And if you don't get something right when you're going to confirm your sale in court, you're going to have problems. So you have to be very particular, and the more work you do ahead of time in the sale, the better off you're going to be
right
when you get to court. So, I like to work with a real estate agent such as Nancy, who knows her stuff. It makes my job, the attorney's job, 10 times easier and prevents problems down the road. I don't always get to work with someone like Nancy because the client is entitled to choose her agent. And sometimes they will just insist on someone, and that someone usually says that they have done probate sales and they know what they're doing. And then, you start working with them and you find out that they don't. And so the attorney has to spend a lot of time in coaching and training.
But don't you find that mainly the paralegal helps a lot with the coaching and the training?
The paralegals, like I said, it's a job where the paralegals can do almost all of the work.
No, I feel from my standpoint, I've been lucky to work with some of the finest paralegals here in Los Angeles.
Yeah.
They've taught me everything.
Yeah, they're great.
They're great.
No doubt about it.
Make friends with the paralegals.
Yeah, exactly.
Forget the lawyers. No,
exactly.
I'm just joking.
Don't forget the lawyers, no.
Anyway.
Okay.
So the first thing that you always do when we hear there's going to be a sale that's a probate, one of the first things we do is order a preliminary title report.
Right.
And why do we do that?
So, you have a client that tells you the title is in the name of the decedent, and if you don't order a preliminary title report, you will oftentimes find surprises as you get in down the road, and then you're kind of scrambling to fix the problems. Such things as the decedent took title in a different name than what's on your probate pleadings.
We just had that happen.
I've had it happen where I've had to go in ex parte and amend the title to the proceedings and add an AKA, also known as name, to the probate proceedings so that title would be happy. But you also want to find out if what liens are on the property.
And if the person isn't aware of it, at least your preliminary title report will give you a place to start.
Right, exactly. And you may have old judgments that you need to clear up. I had a sale not too long ago where we were facing a foreclosure, and there were like really old judgments on title. And because we were facing the foreclosure, it was really difficult to clear up those old judgments. So the sooner you know those problems, the sooner you can start tackling them. So, you know, you want to know if there are any mortgages or liens against the property. And with a lot of times you'll get a probate and there was a reverse mortgage on the property. And sometimes the probate doesn't open until far after the death. The reverse mortgage companies are going to start foreclosure proceedings as soon as they can. Okay, and you should be in touch with them as soon as you get the case. Tell them your intentions, that you're marketing the property, you're going to sell it through probate, and some of them will work with you and hold off on the foreclosure. Some won't. So, you know, it just depends on the company.
The escrow officer we work with says that sometimes she thinks that the reverse mortgage company knows that the person has died before the family knows.
Exactly, I know.
They're very aggressive. So
right on
if you're
it.
dealing with a reverse mortgage, just beware that you really need to be right on top of them.
Yeah. You want to make sure your property, your personal representative has obtained insurance on the property. You know, sometimes personal reps forget these kind of things, so you want to be on them, get insurance. I did have a property that we had confirmed the sale, and then there was a fire on the property. Luckily, it didn't, you know, burn the whole thing down, but there were damages. And you just hate to have your personal rep have to be liable for that. I think one of the first things Nancy asks for, if we have tenants in the property, is she wants to know if there are rental agreements. So you want to get to work on that. Get Nancy or your broker the rental agreements. A lot of times they don't have them.
So
And
I was going to say, early on, you're able to get more information from tenants than you are as things progress. So if you can very early on, you can try to get an estoppel or something from tenants telling you what their situation is so you can check it all out. Yeah,
exactly. And you want to advise your personal representative to inspect each property personally. And I have an experience with that as well. And I'll just let you know that a lot of what I know today is based on mistakes that I've made. So a lot of times we learn by mistakes, and I've made a few. So, you know, we had a situation where our client represented to us that he was the property manager. And so the personal representative let him manage the properties. Well, we didn't go out to inspect all the properties and interview the tenants themselves. Turns out there was a unit or two that he represented were not rented out and needed too much work. And way later down the road, we find out that he was renting them out and pocketing the money. So your personal rep is going to be responsible for that. So you want to advise your personal rep to go out personally, see the property, and make sure, you know, there's somebody there or not there that's supposed to be.
So there's really two methods of selling property in a probate estate.
Right. So in order to figure out how you need to sell the property, there's what's called limited authority and full authority under the Independent Administration of Estates Act. And you usually get that authority when you first file your petition for probate. I have always wanted limited authority, and I have always wanted court confirmation for my sales, because you get a protection from the order confirming the sale. You get a protection that you have sold this property to the satisfaction of the court and complied with all the court's regulations. And it also allows for overbidding in court, limited authority. If you present an offer to court for court confirmation, and you've done all the things to market the property to satisfy the court, and no overbidder shows up and you get that order confirming sale, you're protected from an heir or somebody coming in to say you didn't sell this for the highest price, or you undersold it, whatever. Right. And if you have undersold it for some reason, usually an overbidder will show up in court.
Right.
And then the other method is if you have full powers under IAEA. And a lot of people do like this as well, because it depends on the probate. It depends on the family. It depends,
if people
on
are
the
all,
heirs and beneficiaries.
People are all getting along and everything seems fine.
Right, exactly. Then you can go for full authority. I think it makes Nancy's job
it's a lot easier, but however.
And the way you do that is, you go along a simple procedure of Nancy does her work at getting offers. You do not have to publish. You do not have to get a inventory within 90% of the sales price. What you do need to do is, when you do accept an offer, you need to do a notice of proposed action to the heirs or beneficiaries of the estate.
But generally you prefer to go the other direction. It provides more protection.
Exactly.
People don't like it because people are always worried about, well, we're going to talk more about that, about going into court and having to confirm it and the requirements and et cetera, et cetera. But
yeah. And so you do your notice of proposed action, and that you set forth in that notice all the terms of sale for the offer that you just accepted, and you send it out to all the heirs and beneficiaries, and there's a method to object. They can send back the form and object, and if they do object, then you have to take the offer into court and get it confirmed. If they just don't do anything, you have to provide them at least 15 days notice. If they don't do anything, then that's deemed an acceptance of the offer.
So there's also two types of sales that can take place, and that we're going to talk primarily about a private sale.
Right. There's private sale or auction. I have done both, but the majority of mine have been private sales. I have done auctions. You still have to do your publication, which we haven't really even talked about yet. You do not have to get your property appraised within the 90% value, which we'll talk about later. You still need to publish when the sale's going to take place, and then after it takes place, you still need to confirm it in court if you need court confirmation.
Okay, let's see if I can move this forward now. Okay, wrong page. Okay. So, selection of a real estate agent. I'm going to talk a little bit about that because that's what I do. And one of the things that you'll find is that, and I'm not in any way, shape, or form trying to diminish my fellow real estate agents. So for any of you that are on the line, please don't take this personally. I think one of the things is that a lot of people don't understand the duties of the agent. Our job is to make sure that the property is really marketed. We have it out there and make sure that there's good exposure to market, and that we can when they put a petition into court, they have to explain how the marketing efforts have been done and what we've done as a real estate agent. The other thing that we do is some of the things are selling a property as is. That's a big deal in the probate. It's as is. Now, as is kind of a very confusing term. Everyone thinks that when we sell as is, we literally mean there is as is. Which means that does not mean that a buyer does not have the right to investigate a property, to make their decision, to do any disclosures, but they need to do all their investigation in advance of making their offer and then make their decision based on what they have been advised. So, what do we do to make sure that that the buyer has all the information that they need? Prior to putting any property on the market, we want to make sure we have in our possession to give to a buyer the preliminary title report, the 9A report, any sorts of disclosures that we're aware of are all given to a buyer prior to making any offer on a property. It's really important that your agent be fully armed with all this information, because in any situation, if something is given to somebody at a later date, that may change their information about the property, and they could successfully argue that it's no longer as is to them. Does that help that make sense? And you really need to have someone that's really willing to work with other real estate agents, because we spend a lot of time educating other real estate agents on how to write an offer. What does as is mean? What does all cash mean? All those types of things. So these are really important things to understand. The listing agreement. This is a really interesting way to interview a real estate agent to see if they know anything about a probate sale. Someone once asked me, what's a good question to ask? And I said, ask them, how long is the listing agreement? Because per the code, am I correct?
You are correct.
It's only for 90 days.
Instead of 180
80 or 360, it's only 90 days. In LA, the commission is 5%, period. It is set by local rules. It may be different in other counties. I don't know every county.
There are a couple counties that will approve 6%.
6%.
I know,
but you really need to know your local rules. And on vacant land, it's 10%. And the other thing that you need to know about the listing agreement is that you cannot pay commission to an agent who is a purchaser of a property. It's very important. As a real estate agent, I've many times had an agent on the phone saying they were buying something on their own behalf, and I have to tell them to go get a real estate agent. It's very important. If not, I've had it happen a couple times where the agent's representing themselves, and unfortunately, and it kind of doesn't feel that good, they award us the full commission.
Right.
Yeah, so there is prohibition on that. So it's kind of important that you work with people that know what they're doing. When you market the property, fix it up or don't fix it up. What do you say, Brenda?
Well, I've been coached during my career that we don't fix it up. First of all, you are not guaranteed to get your money back when you put money into it. Second of all, the more work you do, the more liable you are for whatever improvements or fixing up that you did. Whereas, if you didn't do anything, you don't know anything about the property. You can't disclose anything. You
don't know.
You didn't live there. You don't have to disclose anything because you don't You don't really know.
You're
You
an
didn't
exempt.
live there.
I always
So-
advise buyers that, or sellers, I'm sorry, that they should clean it,
Yeah, right. Yeah,
to
definitely.
sanitize it, but that the minute you start painting or doing something, you can inadvertently hide something that you don't mean to. No one has bad intentions, but it kind of opens up your liability. So what you have to do, if you do fix it up, then you have to disclose everything you've done. Time on the market. Generally, these probates only have a 90-day listing agreement, so you really need to kind of, as you market it, know that your time for selling is limited. Disclosure obligations. It's really important that you do not have your personal representative disclose things that they don't need to disclose. Any known defect that they're aware of, they should disclose. But I always tell people you don't need to do a research project. You just, if you know something, you know it. But other than that, you don't, there are lots of forms that the California Association of Realtors presents to a normal seller, and your seller, if they're a personal representative, are exempt. If you need a list of those exemptions, you can email me after this, and I'll be happy to send them to you. Excuse me. And publishing, publication.
Publication. Another thing that I've, learned by error. You get busy sometimes and you forget things, and I have before forgot to publish. But so it's one of the advantages of working with Nancy, actually. She always reminds you, did you publish? And so you need to publish notice of your intent to sell the property. And that publication is good for 1 year. Okay, you need to be relatively, any offers that you accept must substantially comply with the terms of the notice that you publish, okay? And you publish with a local newspaper, and there's a form called Notice of Sale that you can get from Daily Journal, Metropolitan News, and you want to make sure you have your correct legal description from the preliminary title report that you've obtained previously. And one of the things that we do, you also have to set forth, your basic terms. You're selling it as is.
The deposit.
Oh, the deposit is what's important. Is we usually put in the term deposit is 10% of the purchase price or amount is agreeable to the personal representative. Because down the road, you may get into a situation where you do want to accept an offer, a good offer, but they don't have 10%. If you don't have that language in your publication, you're going to get a probate note if in fact your bid deposit is less than 10%. So.
We kind of learned to do that when there was a really bad recession, and a lot of buyers were getting VA loans and FHA loans and other loans that didn't require as much of a down payment on some of our properties, and it really saves the day.
Yeah.
However, I always tell the story of my very, very first real estate sale, which was a long time ago. And interest rates were very, very high, and we went to court, and the attorney, who was not someone I still know, said, we have a problem. And I go, okay, what's the problem? He said, we forgot to publish. And I was like, oh, okay. And he said, but we're going to put ourselves on the mercy of the court to see if they'll let us go forward with this sale. And
how'd that work?
That didn't work.
Yeah.
The court had no mercy. And you also have to make sure sometimes the publication can go stale.
Oh, yeah. It's good for a year.
It's only good for a year.
Yeah.
So if for some reason you take on a property at the end of the publication date, you have to republish. And you can't accept an offer. That's the other thing that happens occasionally prior to the publication date. So occasionally we've all forgotten and we get an offer and someone goes, oops, we didn't publish. So then you have to go back to the person that's made the offer and ask them if they're willing to wait, and then have someone re-sign it off after the publication date. It's a very important thing.
So since this is a nuts and bolts kind of presentation, you send your notice of sale into the newspaper company and ask them to publish. What they do is there's a certain period they have to publish in the local, I believe it's 3 times
over 10 days.
Over 10 days in a local newspaper, and where the property is so situated. And when you send it in, they will send you back a confirmation, and they'll tell you the sale date. That sale date is the date after which, on or before, after you can accept offers on the property. So that's just kind of one of those nuts and bolts things, procedural things is how it works.
It can be a little confusing.
Yeah. No publication is necessary if the will if you have a will situation and it authorizes a sale. Or if you're doing a trust sale, there also are trust sales where some trustees do want to get their sales confirmed in court. I know at least one professional fiduciary who likes to get her sales, who we all know and love, likes to get her sales confirmed in court to protect her. But most trust instruments always authorize the sale of the property, but you have to read the trust, you have to read the will to see if that language is there.
I'm finding from our standpoint, we're seeing some more trust. People are always saying, this is a trust sale, why is it going to court? Sometimes there's feuding family members.
Right.
And people just feel like they're protecting, especially if the trustee is a third party. They feel it just provides them a little extra protection.
Yeah.
Yeah, that's it.
Yeah. And publication is not necessary if the property is 5,000 or less, which in California you're not going to really, very rarely find.
So when we go over the terms of the sale, we talked a little bit we've kind of been talking a bit about it and around it. So one of the terms of the sale is what we talked about is the deposit. It's to be 10% or terms acceptable. And the deposit must be in cash. And that means that when someone makes an offer, they have to provide good funds. Normally it comes in the form of a cashier's check.
Right. I've never gotten cash.
Sometimes people want to wire in a deposit, but it really makes it a problem. So it's usually a 10% cashier's check.
We usually like the deposit cashier's check to be payable to the personal representative, or it can be made to the estate attorney to hold in their client trust account. We like it held outside of escrow, and this is mostly in the event that if a couple situations. If the property is overbid in court, it's very easy to just get the purchaser's deposit back to them right away, which they want because it's already been sitting there for a while, so they want it back. The next situation is if you have to vacate a sale and you want that deposit in your personal rep's hands to hold for damages. We'll get to that later. Okay. Let's see.
That's the main reason is that you really have control of the money.
Yeah, you have control, and
if it goes to an escrow, escrow cannot unilaterally release some money. So a lot of times if you hold it outside of escrow, we've only had, in all my years, I've only had to vacate 2 sales. But at least that way the personal rep has got control of the money.
Right.
So we also talked a little bit about the sale is as is, And as is to everything. It can be, you can make a concession, but for the most part, we recommend people do not. I mean, that includes no termite. Only things that you have to do for the local rules of the state of California. This is one of the more confusing terms, all cash.
Mm-hmm. Yeah.
And all cash basically does not mean, especially in these days and age, most people don't have that much cash around. They do intend to get a loan, but it does mean that it is not contingent on obtaining a loan. And if the buyer, for some reason, is unable to get a loan, then his deposit is at risk.
That's correct. So, there again, it helps when you're working with an experienced real estate agent in probate, because most likely they are going to let that buyer know, you have to be sure that you are going to be able to get your loan, because this sale isn't contingent upon your obtaining your loan. So for some reason, even if the property might not appraise out at what their lender needs, they need to be sure that they can get it. Otherwise, they're on the hook, because people have spent a lot of work getting the sale to this point, and you need to be sure you can get your loan.
One of the things, and there are no contingencies. And when I say that, that's why that means that there's that they've removed all their contingencies. The CAR has a wonderful form called the removal of all contingencies, and it kind of lists everything that can be a contingency, and you have the buyer sign it off on the bottom, check the box that they've removed all contingencies. But it is really important that you provide the buyer with the preliminary title report, the 9A report, any kinds of local disclosures that you need to give them, so that there can be no confusion, and get a receipt for all of that.
Right, and this doesn't mean that someone coming in and making an offer doesn't have the chance to go in and do their inspections, right, Nance?
Right.
They get to go in and do their inspections, right. And if they do want to back out at that point because of this or that,
it's before they make their offer.
Yeah.
One of the reasons that, and I'm kind of backtracking a little bit on our marketing, we always put a property on the market for several weeks at least, so that we can allow people the time to do their investigations. Mm-hmm. We don't put a property on the market on Friday and accept an offer on Monday. So the other thing is the sale of the real estate must be 90% of the probate referee's appraised value. Brenda.
That's right. So, you need to file an inventory and appraisal with the court for the real estate that you're selling. What we do is we hold off on sending the inventory and appraisal to the probate referee until we get an offer, because most often than not, the probate referee will return his appraisal, and that appraisal will be within 90% of the accepted price. The date of death inventory and appraisal is only good for a year. If your sale is after 1 year from date of death, you're going to need a reappraisal for sale. Okay. The court needs to know that the offer you accepted is within the current market price. So you have to get a reappraisal for sale. So,
if I can just interject for a second, one of the things that we've done over the years that's really kind of helped people, the probate referees oftentimes do not go inside a property.
Almost always.
So, yeah. If you feel that your property, and a lot of times the property may or may not be in the world's best condition. So we have found if you can get your real estate agent to go into a property take photos, put it all together, and then be able to give it to everybody so that they can send it off to the probate referee. It kind of assists them in helping them establish a value. Even if you're not selling it right away, it helps to kind of,
It's very helpful.
it's
yeah.
very, very helpful. So you should be able to try and get your real estate agent to help you with it, you know, doing some of this work in terms of getting the value set. It does help. Oops, wrong way. Okay, notice of intended action, if you don't.
Okay, the notice of intended action is what I touched on earlier about if you have full authority, you need to send out a notice of proposed action to the heirs or beneficiaries, informing them that you intend to sell this property and set forth all the material terms of sale. It's a judicial counsel form. I don't know the name, the number right offhand, but it is a form, and you just put in the all the material terms of sale,
Price.
the
terms.
price, as is, no contingencies, whatever the terms are. And as I said before, if someone objects, then you can file a report of sale and get it confirmed in court, and then let them come into court and object if they still want to do so.
So here's the fun part.
The confirmation hearing.
We get to the whole end, and then what happens? This is what happens for us. We end up putting a property on the market, and then we set a date where they're called a bid, they're really a bid that we get, and we ask, to the agents to bring them in. And generally, when we accept a bid, we, just like any other real estate transaction, we are allowed to counter offer. We put the offers out, we counter offer them, we get them back. And from our standpoint, as a real estate agent, we never consider an offer accepted until we have that 10% deposit.
Right.
We're very careful on that because, frankly, more times than not, we end up with buyers that are all excited, and then we say, okay, bring us your money, and they don't bring in their money. And so you don't have a sale without the cash. And we generally give people 24 hours or 1 business day to bring their money in so that we can keep the flow of the marketing on the property going forward. It's really critical that you make sure that you have that deposit. I've heard of instances where people do not get to court and they find out no one's got the money. So I think that's a good reason for keeping it having it in the attorney's account.
Right.
Or if it's an escrow, but make sure you have the money before you go forward. And then you send the attorney all the information and they file a petition.
Right. So after Nancy has done all her good work, she sends us all the information, the completed purchase agreement. The personal rep has the cashier's check for the 10% deposit.
Oh, I want to mention one other thing.
Oh, go ahead.
I forgot.
Go ahead.
It's really important before you that what we do is we want to make sure we know how people are taking title.
Oh, yeah. That's
Yeah, I'm sorry, I totally forgot about that. But we ask that people give us how they're taking title, that they spell their name for us, that they give us their relationships, if they're married, if they're unmarried, and how they intend to hold title. And the reason we ask them to fill it out is that we don't want to be responsible for their errors, because people make mistakes.
Right, yeah.
I've had people that have come up to me after court and say, my name is spelled wrong. And I'm going, really? You didn't notice that your name was spelled wrong? Or my craziest story was that I sold a property once, and the lady looked at me and she said she was a married woman. So put down married woman. And then it turns out she wasn't married, but she was pregnant and embarrassed.
Oh, really?
So then we had to go back and change the whole thing,
Mhm.
which is called what, a nunc-pro-tunc?
Oh, non-pro-tunc, yeah.
I thought it would be better if she just got married, however. No, but
It's a
anyway,
little drastic.
it is very important that you make sure that you know how people are holding title before you make their offer. We forgot to put that on there.
Right,
Sorry.
and in fact, it's part of one thing you have to put in your report of sale. So when Nancy gets me all of the stuff I need, the signed offer and everything, we prepare what's called a report of sale, which is also a judicial counsel form. Pretty easy to follow. And the form, I don't have it in front of me, which I should have done, but just sets forth the purchase price, the bid deposit, who the buyer is, how they are taking title, and it sets forth the commission. And I always put in my petition, we like to have the commission split, even if there is an overbid. So my language would be commission to be split 50% Berkshire Hathaway, 50% to the broker for the buyer, or in the event of an overbid, 50% to Berkshire Hathaway, 50% to the broker for successful overbidder. Because the probate code does provide that if somebody brings in an overbidder,
Right.
that broker is entitled to half of the commission on the original sales price and the full commission on the overbid amount. Okay, so but we like to word it.
The local rules have allowed us to kind of go
Yeah.
around that way. But kind of the fun part is when we go to have a court hearing, and then hopefully we get overbidders, right?
Right.
Yeah. So
That's good.
one of the things that's really important to do is, and we do, we assist a lot with this, is qualifying the buyer. My understanding is that to be a qualified buyer, all you need is to have a check for 10% of the overbid amount in the form of a cashier's check.
Right.
However,
Or cash.
or cash, we've only had a cash a couple times. However, because of the fact that the world is a little litigious and people are always get all excited and then they decide they change their mind,
Mm-hmm.
we actually put a packet together for the buyers to sign where they're receipting for all the same things that the prior buyer has receipted for. So we want to make sure they get a copy of the preliminary title report, the 9A, and everything, so that they can't say, oh, we weren't aware of something. That's our biggest challenge, is making sure someone can't say, oh, I didn't know this.
And that is another great advantage of working with Nancy's company,
so
because
sweet.
they're really good at it, and they help you a lot.
So at the hearing, we qualify the buyer,
Mm-hmm.
and then you restate the terms.
Right. And if if you're an attorney in court and this is your first sale coming up, what you do want to do, and you may not have someone like Nancy at the hearing, you would have to qualify the buyer. And first of all, you get there before the hearing, and you have to publicly announce the sale and ask if there are any overbidders on this property. And if you have people raising their hands, you take them out into the hallway and you qualify them, just like Nancy just said. You want to get their cashier's check. You want to give them the terms of the sale, and any disclosures that you do know of. You want to make sure they know ahead of time what they're getting into, so they can't come back later and say, I didn't know this.
One of the big disclosures that we find too that's important, especially if you're selling any sort of residential income property, you really want to disclose that it's being sold subject to the tenants.
Oh,
Or-
yes.
Or if someone is in the house and you haven't been able to get them out, subject to the tenant, so.
Yeah, we didn't even get into that issue, but we don't have time.
We don't have time, but those are some of the terms that you want to make sure that could be a defect or any unusual condition.
Right. Yeah, that's a big one. We do like to sell it subject to existing tenancy, so we don't have to worry about evicting anyone. Let the buyer do it if you can.
The overbid process.
Okay, the overbid process is next. The first overbid is set forth on page 2 of your report of sale. There's a calculation. The calculation is the original bid amount plus 10% on the first 10,000, which is $1,000, and 5% on the bid less 10,000. Okay, so if you had a bid of $500,000, your calculation would be $500,000 plus your 10% on first 10 of 1,000 and 5% on 490,000, which would be 24,500. So your total first overbid would be 525,500. And so that's on the actual report of sale and pretty easy to calculate. When you are actually overbidding in front of the judge, luckily the judge handles every sale I've done. The judge handles the overbidding himself. I do know that there was, I think, Susan Jibkowski of our firm, who is now retired, or is trying to retire. She told me once she had a overbid where, or a bidding process where the judge made her do it.
Oh, wow. How fun.
So luckily in the LA court, I've only had the judges handle the overbidding, and they set the overbid amount. So they would start with the first overbid, and they could start with increments of 5,000, depending on the price of the property.
Right.
5,000, 10,000. If it's a small amount, 1,000 even. So then, you have a bid in court, right?
And then it's kind of fun. So sometimes the original buyer gets it, sometimes the overbidder gets it.
Yeah.
But anyway, and then you.
So if it is overbid, if it's not overbid, it's all fine. You go back to your office and prepare the order confirming sale, submit it to the court. If you do have an overbid, there is an overbid form that you can get from the clerk. I take my own. It's a Los Angeles County form. And then you fill it out, have the overbidder sign it in court, take it back to the clerk, and that becomes the contract.
And that's a little confusing to buyers sometimes because they want to come into court with a whole real estate contract.
Right.
And unfortunately,
they don't get it.
They don't get it, unfortunately. So, and then following court, it's the same thing. You go and you open up an escrow. And again, it's helpful if you can work with an escrow officer who's familiar with these types of sales. One of our sponsors is an escrow officer that specializes in probates and trusts. We're not supposed to be giving pitches, but we can.
Well, you know what? I work with Marcine because she just is so good at what she does. And I've learned a lot from her, actually.
So we kind of are ending up with the things that go wrong.
Yeah, right.
So
common errors that attorneys find themselves. I had a case recently, well, it was a year or two ago, where this attorney who I knew, who was, a good attorney, but he knew nothing about probate sales. And the client said, all right, that's it. I have to get a new attorney. So they they were referred to us. And the poor attorney, I felt sorry for him looking at all of his work because, it's very specific. And if you don't do what you're supposed to do, you're not going to get your sale confirmed. So common errors is that you didn't file your proof of publication if it's required, or your publication is stale, meaning you sold it after the 1 year that you published. Lack of a proper appraisal, you don't have your 90% appraisal, and your appraisal is more than 1 year old, you didn't do your reappraisal for sale, okay? And then, errors in the petition, which everybody makes mistakes. A lot of times you can correct those by a supplement. And notice deficiencies are huge, because if you don't give notice to someone you're supposed to, that is almost impossible to overcome. And you have to continue your hearing. So you want to be very careful. Look on your case summary, make sure that no one's filed a request for special notice that you don't know about, because sometimes they filed them and didn't send them to you. So that's one of your preliminary things you'd want to do. And I guess that's it.
So anyway, we can hang on. I'm going to stop my screen share.
Nancy and Brenda.
Yes.
Hi.
We got some questions here.
Okay.
Let's start going through them. What's the best legal procedure for stopping a pending foreclosure by a reverse mortgage lender or other lender while you market and sell the property subject to court confirmation if the lender will not agree to hold off?
You have to go into court.
Yeah, you have to go into court. You have to go in on an ex parte. You have an urgent situation, it will probably be granted for a preliminary injunction, temporary restraining order, and preliminary injunction. So that's what you do.
Yeah, unfortunately, these lenders are very, very aggressive, and it's kind of sad because people do not realize when there's a decedent estate, we see this all the time where they just don't react. The family just can't get their act organized to get the property on the market,
Right.
Especially with a reverse mortgage. They are the worst.
Yeah, they're not very kind.
They're not very kind. No. Yeah. Sorry, go ahead, Kevin.
All right, our next question. Please confirm that publication is only required if seeking court approval of the sale, but not if using a notice of proposed action.
That's correct. That is correct.
All right, our next question is, what is the current lead time now in LA Superior Court for the hearing to confirm the sale of real property?
Don't know.
Well, I think Nancy just experienced when you filed
one of the attorneys filed during COVID a petition for a sale in March or May or something, and we got a date in December.
Yeah, so I do believe right now they're setting them 4 months out. And what I've been doing is going in ex parte and obtaining full authority. I've done it like 3 times. If my personal rep only had limited authority, I've gone in ex parte to get full authority for that very reason, because it's a turnoff to buyers if they're going to have to wait 4 months for their sale, and it could even be overbid, so their deposit is tied up for that long. So if anyone needs to email me about that, I've done it 3 or 4 times successfully, and they're being very cooperative at the court downtown about giving us those, granting those petitions.
Great. All right. The next question we have here is, how are overbids handling during COVID?
Well, you know what?
I think this might refer a little bit to, periods are apparent over.
I actually had an overbid in COVID. I've actually been involved with the sale that had an overbid. Again, we set it up a certain way that the night before, that everything had to be, we had to know that the person was going to be there, and we asked that they present everything to us the night before, the check and a copy of everything signed off. No one wants to go to court. I actually ended up with one where I did it remotely and one where we went down to court because we just wanted to make sure we got the check. I mean, it's kind of a touchy situation. The attorney did not come down. I actually went down to court. you've got to kind of work as a team to decide how you're going to do it. I think everyone has to do what they're comfortable with.
Yeah, I haven't experienced it yet because frankly, I've been going in to get full powers, but it's my opinion that the attorney has to go down, at least someone has to be there personally to handle the overbidders, and I believe the attorney should be there.
Our attorney was out of town, so I actually went down and did the whole thing.
I mean, you can still do it safely, I believe. You can wear your mask and maintain your distance, and I believe the courts are...
They have you sit every other seat. You can't sit next to anybody. There was no one there, so it didn't feel scary.
All right, I think this next question goes similar. It's how are you pre-qualifying buyers with remote appearances at the hearings?
Doing the same thing.
I think Nancy's trying to do it as much as she can ahead of time. But if, you can't always pre-qualify somebody, because sometimes people show up like that Nancy wasn't even aware of, or other brokers weren't aware of, didn't expect any overbids. So someone has to be there.
We do we keep track of everyone that calls us on our properties. So a couple days before a hearing, we kind of call everyone to see if they're coming. So we do as much as we can under normal circumstances, and we do it now just to make sure no one's showing up. We have to be very proactive on this. I hope that kind of helps everyone understand.
All right, the next question. Do the same publication rules apply for conservatorship estate sales?
Yes.
Yes, they do. And in a conservatorship, I believe you have to get authority first to be able to sell. I haven't done that many, to be honest with you, conservatorship sales, but I believe, especially if it's the conservatee's residence, you have to get authorization from the court to even sell it. So you do have to publish notice. You do have to, because publishing is one of those, it's a marketing tool. And so you have to show that you've done everything you can to properly market the property.
All right, we have two more questions. Do you need a new purchase agreement after your sale is confirmed to a successful overbidder in court? If not, what are the terms of the sale and what do you provide to escrow?
Okay, so on your overbid form, I mentioned that it's a local form that you can get from the clerk, or you can get it online. It's available online. And in that form, you set forth the terms of the sale, all cash, as in whatever the terms are, you put it in that form.
Or you attach it.
Or you attach it if there's too many. And have the overbidder sign it. That becomes the contract.
It's very confusing, Kevin, because we do have people that think that it's confusing because the lender is looking for a contract.
Right.
But you don't start generating a new contract. The contract is a court order.
Right. You get a court order, and the underlying contract is that overbid form, and it does have the terms of sale in it.
Perfect. All right, our last question. Any suggestions for obtaining insurance on a vacant property?
Yes.
Well, I always use Sorenson Insurance because for that reason, mostly I like them.
And they're the only ones we're really aware of.
Yeah, I like them a lot. And there are a lot of insurance companies that will not insure vacant properties, but Sorenson does. So you might want to contact them.
Yeah, they kind of have been doing it for years, and
I believe they work for the public administrator.
I think they do too. So. They're located in Ventura, but you can look them up. It's called Sorenson Insurance, and they are quick to bind.
They're very nice people.
All right, I think we're all out of time here. So Nancy and Brenda, thank you so much for speaking with us. And our speakers indicated that they're more than happy to answer any questions if you want to send them emails after this presentation.
Thank you.
Thank you.